All right. Welcome to all of our participants today. Welcome to the Hennepin-University Partnership Summer Webinar Series. My name is Sarah Sandgren, and I am a graduate assistant with the HUP, here with HUP Director Kathy Doty and our colleague at the county, Scott Vargo. Thanks for joining us virtually today. A few Zoom reminders. Your video and audio are not enabled as participants, but we will ask that you use the chat and Q&A function. So if you can find that on your Zoom, there will be an option, a button along the bottom of your Zoom window to use those functions as we get started. Please chat us if you have any tech issues or other questions as well. And a note that this webinar will be recorded, so it will be available after the fact. And one last announcement from the HUP, our later July summer webinar series date is also open for registration. That will be a panel featuring experts from both Hennepin County and the university in a presentation and discussion called Sniffing Out the Value of Anaerobic Digestion. Find more information and sign up on our events page at hup.umn.edu for that. And now I'm very excited to introduce our speaker for today, Professor Linus Chan. He is an associate professor of clinical law at the University of Minnesota Law School and director of the Detainee Rights Clinic at the law school's Binger Center for New Americans. Professor Chan is an immigration attorney that focuses on removal defense for those detained by Immigration and Customs Enforcement, and also teaches in the area of the intersection of criminal and immigration law. It was recently announced by the National Immigration Project of the National Lawyers Guild that Professor Chan will be honored by them at the 2020 American Immigration Lawyers Association virtual conference later this month for outstanding contributions to the cause of immigrant justice. So we are very excited to have him here today to present to us about immigration. Welcome, Professor Chan, and take it away.
So thank you, everyone, for inviting me and having me come. So it is always, and I'm still getting used to the idea of speaking from my basement to a whole bunch of other folks, but we'll see what we can do. So when I was first asked to present, I was trying to figure out if there was a way that I can talk about what's been happening in immigration law that is with any sort of themes or an idea that would make things easier to digest. Unfortunately, since I agreed to do it, there's been consistent and continual changes, what might be described as almost upheavals in the immigration system. And really it just comes down to, unfortunately, all I will really try to talk about is the fact of trying to explain all the different dizzying and somewhat overwhelming news that's coming on the immigration side. And I'm going to be doing so in one way, which is I'm going to talk about what is affecting legal immigration, right? This is all the new rules and changes that are going to be affecting people who are seeking to come in the United States, usually visas and other proper channels. And then at the end, I'm going to start talking a little bit about immigration enforcement and what changes we might see there. Everything is subject to change. Like literally just now, I just received an email that the Trump administration is publishing a new rule, which I will try to get to about asylum and COVID-19. There are rumors, of course, that there will continue to be new rules. So I will just say everything is with a caveat. Everything can be affected either from federal courts, as I'm sure some of you know, there's new lawsuits were just filed today based on things that happened 2 days ago. Court cases are being decided now. So things change. But I wanted to give just a general overview, hopefully to try to make things a little less overwhelming. But before I start, and I'd like to do this just to make sure that what I'm saying will be as useful as it can be to the audience. If you could, in your chat function or Q&A function, if you can just go ahead and let me know what are some burning questions that you want to make sure that I touch upon. And what I'll try to do is I'll try to answer some of those questions as we talk. And then At the end, I will, if I haven't answered some questions that were mentioned, or if you have additional questions, we're happy to do a kind of a question and answer format for that as well. So I'll just go ahead and leave a little bit of time for you guys to put in some burning topics that you want to make sure that I get to. So I hope everyone has access to that. If you don't, then you're going to be subject to what I am curious about, as well as what I think might be important. So we'll see whether that's worthwhile or not. So just a couple more things. You guys are frozen. Is everybody else around?
It's working okay for me.
Okay, great. I just wasn't sure. All right. I don't see any chat. Is that right?
I haven't seen any yet either, but please do submit.
No problem. While you're doing it, if while I'm talking you want to answer, I'll try to do that, but we can see what's going on. All right, so everyone can hear me just fine. We're going forward. All right, so let's talk about some of the stuff. So some of the stuff that I'm going to talk about has been in the works for a while, but there are new things that are happening. For instance, public charge is something that I will talk about, but some of the stuff is just brand new, right? The new ICE rules about student visas and how that's going to be affecting. So I wanted to talk about legal immigration. And the first thing that needs to be known, of course, is way back then, in April of this year, the president proclaimed a pause on all immigrant visas. And the president did so on April 23rd, and that pause is supposed to last until December of 2020, with a likely review and potential to renew this pause. Now, the president did so because in his estimation, he thought it would be necessary to protect the jobs market inside the United States. And so by doing so, he went ahead and said there will be no new immigrant visas that will be granted while we are undergoing this pandemic. So what does that mean? Well, first of all, the way to think about it is, who does it not affect? This does not affect refugees, but those refugee numbers were extremely small and delayed anyway. So people who are coming in as refugees, and this does not include asylum seekers, these are people who are processed overseas as refugees and coming into the United States. So for those of us here, we're very familiar, of course, with the Hmong population, with the Somali population. Many of those folks were refugees living in a refugee camp, then were getting refugee status and allowed to come to the United States. Well, that program has gone slowly lower and lower. We're at the lowest numbers of refugee admissions ever in the United States since the program started. That program is not affected by this presidential proclamation. However, it's already been at an extremely low levels. This does not affect people who are seeking asylum. There's a whole other set of things that are changing the asylum stuff, which I will get to later. This also proclamation doesn't affect U.S. Children under 21 of U.S. citizens. So if you are a minor child of a U.S. citizen and you're seeking to come to the United States with a green card, then you are allowed to come. Now, minor children of U.S. citizens may also be citizens, but there are a subset of folks who are not citizens who would be allowed to get a green card. The presidential proclamation does not prevent minor children of U.S. citizens from getting the green card. Another notable exception is immigrant visas for what's called EB-5 visas. EB-5 visas are what's called entrepreneurial visas. These are the people that needs to show that they will provide $1 million of income into the United States. So notably, of course, because the president has said this is to protect jobs and to create better economies, those people on those type of visas are allowed to come into the United States. with an immigrant visa. However, everybody else is affected. Now, if you already have a green card, if you already are a lawful permanent resident, then this proclamation doesn't prevent you from entering the United States. But if you were in the process of getting a green card, for instance, if you were married to a US citizen and you were outside the United States, this only affects people who are outside the United States, and you were outside the United States and you still had not gotten your visa, well, this proclamation has put a pause on that process and you will not be able to get your visa to come into the United States. And that rule is in place in April, and it looks like it's going to be extended through till December. Just more recently, in June, on an effective date of June 24th, the president also made a proclamation affecting non-immigrant visas. So these are people who are coming in on H-1s or H-2s. These are work visas. This is also people who are on a J visa. This is a non-immigrant exchange visa program. Now, it's important that the J visas, that this non-immigrant visa pause or ban, or however you want to call it, does not affect students yet. So these are mostly J visas that are non-student oriented, right? So the J programs might include the seasonal worker programs. If some of you know, for instance, a lot of the seasonal workers who work in kind of the travel oasis on the high freeways, people who work in those small towns, a lot of them come in as J visa holders. This does put a pause on them. L visas, which is also a smaller used type of visa, are also put on pause. So if you are, one, outside the United States, two, do not actually have the visas on June 24th, 2020, then you will not get those visas. And that proclamation is going on a 60-day rolling basis. So it's good from June 24th until August, and then they will revisit that proclamation and keep going for another 60 days. So again, if you are not in those areas, if you're not in the United States, you don't have it, you're waiting for a J visa, an H-2 visa, or an H-1 visa, or an L visa, you're out of luck. You're not actually going to get one until this proclamation is lifted. The exceptions, of course, apply to people who are working, and this applies to the immigrant visas as well. If you are a doctor, nurse, or healthcare professional working and in ways to help the COVID crisis, and it will also apply people who are working in the food supply area are also exempted from this rule. So for instance, if you had an H-1 seasonal worker in a meat packing plant, you likely will be exempted. It's unclear about normal farm worker supply. So for instance, people who are doing agricultural work in the fields, how much this exemption applies. But from my understanding right now, if it's not on the essential food chain, then it would apply. If it's called the essential food chain, then you might be exempted and those H-1s can still come in. So those are the two important proclamations that are in place right now. These are done just purely by the president. The Congress has not weighed in on this. There are, of course, likely lawsuits that are trying to prevent these proclamations from going forward. But just if you guys remember, the Muslim ban or the travel ban, when the Supreme Court took on those cases, they basically said to the administration that the president has a broad authority to pause during national crisis and whatnot. And that's going to be the legal justification that this administration has used. Of course, lawsuits are challenging that justification. They're saying that it's not a sufficient one, or that it's vague, it's unclear. So we'll see exactly how that plays out. But at least in the immediate short term, those proclamations are in place, they're active, and they're ongoing and what they're going for. Okay. The other sort of big, and this is something that has been brewing for quite some time, but has become finalized in February, which is the public charge rule. So For those of you who remember, last year around this time, the government announced changes to the public charge rule. And the changes to the public charge rule caused chaos, right? I mean, it was a change in basically, it changed how people could be denied visas, immigrant visas, for coming into the United States based on whether or not they may become a public charge. And just to really shortly encapsulate what some of that rule was, is a lot of old assistance programs. So the old rule was essentially, if you weren't getting direct cash assistance, then any other sort of supplementary assistance programs would not account against you in terms of a public charge rule. So if you were getting housing benefits, or you're getting Medicaid or SNAP benefits, food stamps, these were not going to be programs that would ding you when you were trying to get your green card and become and stay and become an immigrant or a green card holder. But the new rule would have changed all that. Now, it's important to remember that any sort of determination about public charge is supposed to be only forward-looking. So what they're supposed to be saying is, in the next 3 years, what is the likelihood that you will become a public charge of the government? Meaning, during the next 3 years, how likely are you going to need at least 1 year or more of the public assistance that might qualify you as public charge? What you have gotten in the past can be helpful in deciding what the likelihood of the future is. But it's not supposed to be dispositive, meaning that if you can show, for instance, that yes, maybe 2 years ago you were on SNAP benefits or you were on cash assistance programs, but for the last year you have a good job and you haven't needed any of those programs, and there's a good reason to believe that you won't need it going forward, then despite a history of getting those public benefits, you can make a showing that you won't get it in the future. But of course, this is very frightening for a lot of people because we don't know, and we still don't know exactly how this is going to be applied going forward. So the new rule essentially says that officers now have discretion to use, other than cash assistance, a basis for deciding public charge. And that includes, again, Medicaid, SNAP, Section 8 housing. And that discretion is where it's really sort of scary for folks, because allowing individual officers to have discretion will likely mean that it's going to be applied differently depending on different offices and depending on different officers. So it's going to be difficult for us to give guidance for people. For instance, you've been on SNAP benefits for 1 month, but perhaps you can show that you won't be. Therefore, you might still be successful in getting your green card. That might be helpful for one person in Chicago and then not be so helpful for another person in Arizona, right? So these are the sort of difficulties that's going to come about with the new public charge rule. There were exemptions to the public charge rule. So for instance, if you were pregnant and you're receiving public benefits, that would not count against you. And then this is another one that's just kind of hard to kind of fit around, but emergency Medicaid should also not count against you. Now, obviously, emergency Medicaid shouldn't count against you in the context of, if it's a past emergency, there's no reason to think that that future emergency would come about. But this becomes harder when someone has a chronic medical condition, right? A chronic medical condition could be an emergency situation, but might keep cropping up in the future. And medical conditions and medical issues are part of the factoring decisions that an officer can use to decide whether or not a person would be a public charge. Now, there was talk also of saying that you could overcome public charge if you could put up a cash bond. Bonds could be at a minimum of $8,100. So for instance, if an officer would say, looks like you're going to be a public charge, but then you somehow put up a bond of a certain amount of money, then they may still allow you to get your immigrant visa, subject to the idea, of course, that the money would become forfeit if you do become a public charge in the future. But again, these things haven't been implemented yet. They're just in writing, they're abstractly there, available, and we're still sort of struggling to what happened. So what happened? Well, a lot of lawsuits happened. There were several different injunctions. I think at least 4 different Circuit Court of Appeals enjoined and upheld injunctions on the public charge rule. There were several nationwide injunctions. Then there was an injunction that was Illinois only. The federal government, as they appealed, they asked the Supreme Court to remove those injunctions, and those injunctions have been removed. So there is nothing preventing the government from implementing, and they have implemented the public charge rule as of February of this year. Now, does that mean it's over? And the answer is no. The litigation is still going on. The litigation will likely be heard in the Supreme Court. But it does mean that in the meantime, while the lawsuits are going, the federal government is able to institute and implement the final public charge rules. And they're here, they're in place. There's been a minor change through COVID, right? Once the pandemic hit, the government has issued an exception. So if someone is getting treated, tested for COVID-19, and those payments are coming through Medicaid or other sorts of state-sponsored programs, those will not count against you for the public charge rule. But it's unclear, of course, how that's actually going to be implemented, and we're still figuring out what's happening. As you can imagine, there were not a whole lot of cases starting in February 2020 going forward that's been affected, because from February 2020 to April of 2020, right, which only a 2-month window, the president issued that proclamation stopping all immigrant visas. So from then on, from April to 2020 till now, there haven't been any immigrant visas being processed. So there haven't been any denials based on that. Now, that doesn't apply to people in the United States filing for what's called adjustment of status, trying to get a green card while they're in the United States. Those are ongoing, and those are going to see applications of the public charge rule. But I will say things are still extremely slow. For a long time, USCIS, after the pandemic, sort of shut down operations for a while. They've restarted in June to go ahead and process both naturalizations and adjustment cases. So we should be seeing what the actual application will be going for. So those are the public charge rule and how that's going on with that. So just to recap, right? We've got 2 presidential proclamations, one stopping immigrant visas. Those are people from abroad coming in on an immigrant visa. That's been in place in April. Then another one in June, stopping non-immigrant visas. These are employment-based visas, H1, H2s, Js, and M and L visas. And then you have the public charge rule, which affects all of that sort of legal immigration aspect. So again, I'm taking on the theme of I'm first talking about legal immigration, and then I see a question about undocumented folks. I will get towards the undocumented folks towards the end of the situation and talking about that. So those are the non-immigrant, immigrant visas. The next thing are student visas, right? I'm sure some of you have heard recently the new rule that was just announced. What's important to know about that is that it's essentially reverting back to a pre-COVID rule. So what had happened is when COVID hit and universities were suddenly going, wait a minute, we can't have in-person instruction during the spring semester. We're going to switch to online instruction or virtual instruction. Well, there was at that time an in-place rule that was designed to prevent people from coming into the United States on an F visa or student or a J visa from enrolling in purely online universities. You could think about University of Phoenix and online schools, and having access to coming into the United States despite only doing online schooling. So that was the old rule. COVID happened, and a lot of, all mainstream universities said, wait a minute, pause, we're gonna have to go through online instruction, we have to prevent this. And at that time, ICE went ahead and said, we're gonna release an exemption from that old rule that says it doesn't need to apply. If you're gonna be, if you're an online student, and this is of course what had to happen because you had a whole bunch of international students already here. And then suddenly all their courses changed online, and to force them to go back during that period seemed specifically unwise. Well, what has happened is I said, going forward for the fall semester, we're going back to that old rule. So that if the universities are either online only or hybrid, then you will likely not be allowed to stay in the United States if you take more than one online course, right? So even the schools that have a hybrid sort of rule, where they have some online instruction and some in-person instruction, which I think University of Minnesota is qualified as one of those schools that's doing that, then those international students will not be allowed to stay unless they can cobble together only one online class and the rest being in-person class during the time they're here. And this applies to people who are trying to come in on student visas, but also applies to people who are here on student visas. So the rule they specifically say is they might be subject to removal if they in fact try to stay in the United States in an online university situation. This is brand new, just happening just today. MIT and Harvard filed a lawsuit trying to enjoin the government from implementing this rule. We'll see how it plays out. A lot of the arguments that were used in that rule were used in the DACA decision that was just passed, which is called the Administrative Procedures Act sort of rule. And we can talk a little bit about what that might look like in just a second. But we'll see what's going to happen. It's very likely that universities throughout the country are going to be suing. So I wouldn't be surprised if University of Minnesota, Big Ten, obviously a lot of the schools out west that rely on international students will likely be suing and trying to prevent the implementation of that rule, because it will likely become something that affects universities, unfortunately, the bottom line, as well as international students. One thing that I haven't heard talk about a lot is that some of the international students that are here, they're here on student visas, but since the pandemic has been going on, and I think this applies to some of the Chinese students, China is not allowing them to come back during the pandemic. And of course, because the United States has one of the highest numbers of cases, a lot of countries may have restrictions on their ability for them to come back, or either they'll be coming back into severe quarantine. So it really is going to put a lot of people in a limbo type status and making tough choices as the fall semester goes on and what's going to have to happen to them. It's not clear exactly, but that's where we're at. Okay. The DACA decision. All right. So for those of you, I'll just do a very, very quick recap of DACA. DACA was a program that was done through President Obama's administration. It came about in 2012, and we're in 8 years of this program, which essentially was President Obama at the time had said, we need to find a way to protect people who are so-called dreamers, people who were brought into the United States, who are undocumented as children, and Congress is not willing or able to fix this problem. So while we wait for Congress to fix it, I'm going to issue the rule that says we're not going to deport people who are in that situation. They're going to be what's called lowest in priority for enforcement. And B, because of that, we're also going to allow them to file for work authorization. And work authorization was expressly important because it gave these young folks an ability to get a Social Security card, and that allowed them, for all of you folks, to a buy-in to getting proper documentation for states that did not otherwise authorize, for instance, driver's licenses for people who are undocumented. And so it not only affected work, but it suddenly gave people who were in that status the ability to access universities and loan programs and other ways to fully participate in society. So it became a big deal. Now, when President Trump came into office in 2016, he had made promises on the campaign trail that he was going to end DACA. And he was going to do so in a way because, you know, it was part of his campaign of anti-immigration rhetoric. And then there were several attempts to end DACA. And what was confusing about the several attempts is that the Trump administration, at first, they were declaring the program that President Obama had said was illegal. It said President Obama didn't have the authority to do it, so that's why we're ending it. But that's not what they said when they actually ended the program. And then it became this huge mess that they issued one reason why they were ending DACA, and then several weeks later, essentially, after the acting Homeland Security Director stepped down, they issued new guidance from the Department of Justice saying this is the reason why we're ending the program. Well, this sort of confusion at the top, so to speak, was the basis for several lawsuits saying you can't do it this way. Like, it's important to note that everyone had said and acknowledged that the Trump administration can cancel DACA. There's no question that one presidential administration has the power to rescind another president's program if Congress had never stepped in. And Congress, remember, never stepped in. So there was no argument that President Trump could not rescind DACA. The argument, however, came in, if you're going to rescind DACA, you need to give an actual reason that made sense, that wasn't what's called arbitrary and capricious. And you need to, at the time, consider what's called a reliance interest. What's going to happen to the people who are relying on the old program? And ultimately, the Supreme Court agreed with that notion that the Trump administration, while it had the power to rescind DACA, it couldn't do so in the manner that it tried to do so. One, it gave two reasons. The second reason the Supreme Court wasn't going to consider, because they could only consider the first reason, which was the one that they were doing it at the same time. And that reason wasn't sufficient. It was non-reasoned. It wasn't really made sense. And then second, there was no indication that the government, prior to rescinding DACA, had actually considered the reliance interest of all those folks who were in the program. And so what happened was the Supreme Court essentially said, DACA is not canceled for now. But what it does do is it basically says to the administration, if you want to cancel DACA, here are the steps that you need to go through in doing it. The Trump administration has publicly declared they are going to go through that steps to go and do it. Now, the timing of all this will likely mean that DACA will not be canceled prior to the election, and maybe even prior to the new administration coming in January. I say new because that's my hope, but I will say that if President Trump does win re-election, then it's very likely you'll see DACA end very early in that administration. They've publicly declared that's what they're doing and that's what's going to happen. And the lawsuit in the Supreme Court doesn't stop them from rescinding. It just tells them that they need to go through other steps in order to do so. So that's likely what's going to happen to DACA. What does that mean on the ground? It means that for now, USCIS, which is the organization that takes these visa applications and DACA benefit applications, they have to still take those applications and process them. It does mean that people will not be removed with having DACA, but this is a very fine point. I want to highlight this. Just because I have DACA, right, does not mean that I can't be put in to removal proceedings. It simply means that I can't physically be removed. What that has played out on the ground is, if I have DACA, and let's say I get arrested for something, whether it's a DUI or some other crime, the government will put me into removal proceedings. They acknowledge that I have DACA and that as long as I have DACA, I can't get removed. But at the same time they put me into removal proceedings, they will then send an application out to USCIS. USCIS will then consider whether they could remove DACA. And even under the Obama administration's DACA program, there were considerations that allowed people to be removed from the DACA program. So what would happen is government puts someone who has DACA in removal proceedings, then they would get the order of removal, but they know that they can't execute that order of removal until USCIS removes DACA. And that was happening in certain cases. So people were being put in that situation, even though they have DACA, that they would later get DACA rescinded from them based on accusations of, usually public safety was one of the reasons why, and DUIs were a common reason. Then the removal order would kick in and they would go ahead and remove people, even if they were technically at DACA. But otherwise, DACA is for now in place until and unless something changes. All right, so that's DACA. All of this is what I'm talking about in terms of immigrant visas, right? Non-immigrant visas, student visas, DACA. They're all being processed through the agency known as USCIS, U.S. Immigration and Customs Services. USCIS is the benefits processing agency. Why am I talking about them? Well, one of the big news that happened in the last few weeks was that USCIS announced that they were doing significant furloughs and layoffs. And the reason why was because they had no money. So USCIS is a very unique government administration in that they are not funded through Congress. All of the fees that come across with all of the applications, the naturalization fees, the processing fees for adjustment, the employment fees, all of that funds USCIS. And what was happening, of course, is because the administration has done quite a bit of work in trying to discourage a lot of eligibility for a lot of immigration programs, what you saw was a nosedive in fees that were being collected by USCIS. At the same time, then the pandemic hit and you saw a complete stop. And so what ended up happening is USCIS said they had no money. And of course, with no money, that meant that they needed to furlough and lay off people. And when you furlough and lay off people, you're not actually processing the applications that are coming in. And so one of the big problems that a lot of folks in the immigration field are doing is worrying whether everything is essentially going to grind to a halt anyway. You already had saw long processing times. Like work visas were already taking much longer than they had in the past. U visas were taking 3 to 4 years. Processing for adjustment were taking years and years. And so now with furloughs and cutting of staff, you're going to see those go even farther out. And then, of course, what that would mean is essentially it becomes a black hole where people can apply, but they're not necessarily getting anything back for a number of years. And that's a big concern when everything sort of hinges on what's going to happen. There's been a request to Congress to fund USCIS, but right now there's a fight, of course, between the House and the Senate on what that would look like. The House is going to want to put in provisions, for instance, to try to decrease child separation, people who are held at the border, detention policies, all of that. The Senate, of course, is not going to want to do that, and the president is not going to want to do that. To be quite frank, there's a lot of line of thinking of people that the Trump administration would be happy if it doesn't get funded, because that would mean, again, everything gets grinded to a halt. So I kind of wanted to wrap a little bit of this up of quote unquote legal immigration to just talk about that this administration has been doing everything not just on undocumented immigration, but has really tried to overhaul and stop legal immigration. And they have largely succeeded. They have, the latest proclamations have really ground to a halt of much of the legal immigration that's coming into the United States. It is something that is an expressed policy from some members of the administration. And so it is like these policies are doing what they're intending to do. The other thing I will say is, as you can see, the timing and number of the proclamations, and I don't even think I've gotten to all of them. Like, for instance, there's a few of them that I haven't touched upon, that they're just not going to stop. And it doesn't matter if lawsuits will stop one thing, they're just going to keep going for another thing to go on. And that's the best illustration of that is what's happening with asylum. Under asylum laws, what was going on is, with much ballyhoo last year, they announced these regulations called the third country transit ban. And essentially what that was if you were trying to get asylum in the United States, but you traveled through other countries, which is the most common way, right? If you're in Central America and you're not in Mexico, and you're trying to come to the United States to apply for asylum, guess what? You're going through other countries. If you're in, and this was happening quite a bit, people in Africa would travel all the way through South America in order to apply for asylum in the United States. Guess what? The third country ban, as USCIS and the regulations from the administration said, you're not allowed to apply for asylum unless you go through some really strict rules that really were not feasible for most people applying for asylum. Well, guess what? Those several lawsuits happened. The lawsuits enjoined the policy. Then the Supreme Court stepped in and removed those injunctions, but they were still going on forward. Well, recently, the Ninth Circuit Court of Appeals and the District Court in Washington, D.C. went ahead and made the rulings that the third country transit ban violate asylum law. One did it based on the administrative rules, the same way that you talked about with DACA. The other one did it based on immigration law specifically and said it violated immigration law. Well, so great. The third country ban is no longer going to be readily applicable. It's unclear exactly where it's going to be able to actually be applied and used, given the flurry of injunctions and the removal of injunctions and all of that. But, of course, in June, the administration already came out with another full set of changes to the asylum regulations, some of it which were way more draconian than just the third country ban. Things that, and I don't even know if I could get through all of this, but essentially things like making it so it's harder for people seeking asylum to file for work authorization. That was actually published prior to the June 15th rule. It was published in June earlier or later, I forget which, but made it, for instance, people from a lot of Central American countries who were trying to apply based on gang violence, they were no longer going to be able to apply for asylum. It made it possible for officers to prevent people from going to court to apply for asylum. There were a whole list of different ways that they were going to overhaul the asylum process and system in June 15th. Of course, there will be lawsuits to be suing to try to make it illegal. And again, there will likely be another interplay that goes all the way to the Supreme Court, deciding about whether or not these will be lawful. But the point I want to make is, even as things get stopped, this administration is still going to keep putting out newer and newer rules designed to implement what they want. And what they want is essentially very, very low immigration close to zero. And I don't think that's a surprise. I don't think it's even something that they're hiding. They really view the immigration system overall as a broken system, and they view immigration as a system that needs to just essentially become restrictionist. Okay. The question was asked, right now, there is no actual protection. If you're undocumented, and let's say you're working in a meat packing plant, which is considered an essential food chain thing, there's no protection designed for that. There's nothing that says that the government won't remove someone simply because, let's say, you're undocumented and you're a doctor on the front lines of COVID. There were, in fact, some early profile cases where there were doctors who were working on the front lines in New York City. There were some high profile cases, and they had lost out on some sort of, prior to COVID, they were in the process of getting removed, and there was a big push to prevent their removal. So on those individual cases, there might be some ways to convince a humanitarian sort of parole or ideal. But I will say, you're going to get a lot more traction on healthcare workers and doctors than you would, for instance, on meatpacking workers and meatpacking workers who are still considered, of course, essential workers in this economy. They're not likely going to garnish a whole lot of either attention or movement from USCIS on that. So I wanted to leave some time for question, but I really want to just touch on a couple things that are really things that are going to be more uncertain and also imply on enforcement. One, there was a case in the Supreme Court that basically said that that's very important, that's very technical, but is really unclear. And one of the reasons I wanted to point it out is that the Supreme Court, in making its decision, which was essentially a case that said that people who entered the United States without authorization and were immediately picked up and wanted to file a lawsuit for what's called a habeas, the rules that prevented them from filing habeases were valid and not a violation of what's called the suspension clause. Okay, that's very technical, seems like it doesn't mean that much, but the case is important because the justices in those cases had to decide whether or not those folks had due process rights generally. And there is language in that case that indicates that they did not. It's not clear whether it's simply because they were only in the United States for a short amount of time, or whether it's due to the fact that they came in unauthorized. And this could potentially change constitutionally what sort of rights people who are undocumented might have going forward. There's already been sort of an old push for this ideal because a long time old school thinking about constitutional rights were it adheres to people, not citizens, right? But that rule is sort of starting to bleed through a little bit, and that's a whole area of uncertainty that we don't know. Another thing that came out that was very important, the administration is trying to expand what's called expedited removal. Expedited removal was what's known as a border policy, meaning that if someone was found within 100 miles of the border, and that person couldn't prove that they've been in the United States for at least 2 weeks, then the government can remove them without giving them a hearing. That's been the old rule. The government is trying to expand that rule to say anyone found anywhere in the United States who could not show that they've been in the United States for more than 2 years could be removed without a process of going forward in front of a judge. And there was a DC court, Court of Appeals recently that said that was not a violation of the Constitution. That will still play out. That has not taken place on the ground yet, but if it does, it will have long-reaching implications and effects. So that's one area that's also unclear. Okay, so let me go ahead and get to some more. We have about 10 minutes for questions. And I have a couple, so I wanted to make sure I get through them. Now is the time to go ahead and ask more questions. So what I see here is, can having a DUI be reason for an automatic denial of citizenship? No, there is no automatic denial. Now, when you're applying to get naturalized, when you're applying for citizenship and naturalization, you do have to show something called good moral character. And under the good moral character clause, getting an arrest for a DUI can absolutely be a reason for the government to say you haven't proven good moral character. There's two provisions here that are important on the good moral character clause. One is any arrest for any crimes. You can't be on probation during the time that you file for your naturalization. And you can't have spent more than 180 days in jail. Those are automatic denials based on good moral characters for crime situations. There are other bases for denial for other crimes that are what's called aggravated felonies, but those aren't usually DUIs. The other thing that is important is if you have DUIs, the government will also wonder whether you're quote unquote a habitual drunkard, because an habitual drunkard can also be denied on good moral character grounds, but that will require a case-by-case situation. How recent was the DUI? What's going on? Do you have a long history? Were you ever institutionalized for alcoholism? What kind of recovery or treatment are you in? So hopefully that will answer that one. I think I covered the undocumented folks working in essential industries. There has been some examples of discretion, and those were examples of people living in New York who were frontline healthcare workers, usually of the doctor variety rather than, for instance, of the healthcare or hospital worker variety. But there is no actual provision that helps them. It's just purely a matter of grace and getting as much community support on that. And then, do I assume that the detention will remain open despite the spread of COVID? Unfortunately, there have been several lawsuits that have been trying to get individuals out based on high risk health. So outside of Minnesota, some have been successful in forcing the release of certain people, especially in areas that are hotspots, like Southern California. I believe in New Jersey, there was some successful lawsuits in New York. Those usually required confirmed cases within the actual detention center before people were allowed to be released. But those lawsuits were not successful in Minnesota. There were, by count, I believe at least 3 lawsuits seeking release of people who were at higher risk of COVID from immigration detention centers. Now the question asks whether they're generally going to be open, and I think the answer is going to be yes. There's just not going to be any momentum in closing them completely. You see that in a lot of federal court declarations, ICE has claimed that they're keeping population numbers low, and it's true. For instance, Minnesota, the numbers are lower than they've ever been, and that will allow them to control. But there's also a lot of counter arguments that it really is impossible, like even with lower numbers, it's impossible to social distance. There's just really no way to control an outbreak once it's happened in a jail or prison. But I don't see anything in the near future that changing. You know, obviously the examples you see is that they're not closing prisons, they're not closing county jails. They are trying to reduce those populations, but as long as those are open, it's going to be really hard to see the federal government being able to say that they'll close immigration detention centers. So we have, next question is it beneficial to people applying for status to show that they have U.S. citizen children and are paying child support? Yes. Again, under a good moral character clause, if they have U.S. citizen children and are not paying child support, then that's can be a problem, discretionarily wise. So if they have children and they are required to pay child support, then it is a good thing for them to show that they have kept up their payments and that they are not delinquent in Sounds like a lot of these next question. It sounds like a number of these changes are coming from the executive branch. That's true. Because Congress has not enacted any of these changes. Would many of these policies be quickly reversed under a Democratic administration, and are the impact is going to be hard to reverse? So there's two ways to answer this question. The first way is, again, a new administration can reverse old administration policies. There are two ways to do that. The first way to do it is what's called the Administrative Procedures Act. And that is, they need to go through the hoops that the Supreme Court said needed to go through for DACA. So they needed to consider any reliance interest changes, they needed to give a proper reason for changing the administration, and then they need to go through what's called a notice and comment period. So if they do it that way, a lot of these changes won't happen for another, at least 6 months before those policies can be reversed. However, there is another way to reverse those policies. But that requires both houses, both Congress and Senate, to also agree of what's called a vote of disapproval of those. So for instance, if the House and the Senate both make a rule saying that they disapprove of the prior administration's rule, then the new administration can reverse that policy without having to go through all the hoops that the Administrative APA Act requires. However, it takes both houses to do that. So the way to answer the question is, if the Senate remains under GOP control, then the new administration will be forced to go through the APA route, because it's unlikely that the Senate will go ahead and mark their approval of the prior administration's rules. The other thing to say is, what are the long-lasting effects? Well, one of the things that during the beginning of the Trump administration's part, a lot of people were talking about, well, see, they haven't done anything, it's not so bad, it's whatever. But the problem is immigration is a huge bureaucratic institution, and it's like a giant, giant ship. And it takes a lot of energy to steer it in one way or the other. And you can see this with bureaucratic hiring. For instance, Border Patrol and ICE are the largest federal law enforcement agencies in the country. They're much bigger than FBI or ATF. They're huge comparatively. Then you have everyone that's being employed by USCIS, then you have line item. So bureaucratically, even if you wanted to change some of those things, just in the logistical bureaucratic sense, this stuff is going to be with us for a long, long time. They've affected lots of different institutions, including immigration courts, including, of course, federal courts, but a lot of agencies would require a complete overhaul to change things. So we're likely going to see the effects of a lot of these changes. Even if they're technically reversed, the effects are going to be with us for a long time. And I will say, I think there's been a huge erosion of community trust in these agencies and what's going on. And I think that is going to be one of the longest term effects that's going to be really difficult to change. Okay. I think that's the last question, and I just came in under the wire, I think, so.
Yes, it is just about noon. So we just want to say thank you so much to Professor Chan, and also thank you to all of our attendees for joining us.
And if I can just jump in and say thank you as well. And I want to remind all of our participants that if you have specific things that you think you'd like to invite Professor Chan to come talk to your unit or your department or something of specific interest, we'd be happy to kind of set that up based on the availability of Professor Chan. But this is just to give you an opportunity and to learn more and to know about this resource that we have available to us through the University of Minnesota Law School. So thank you very much for your participation, and thank you very much, Professor Chan.
Thanks, everyone.
We'll sign off then.
Wanna wrap it up, Sarah?
Stay safe. Bye.
All right.
Thank you. Goodbye.
Bye, everybody.